Hi, this is Daniel Marks of articlev.org. I wanted to do a quick video explaining what the heck this page is. If you've clicked on this page and you're wondering what requirements are satisfied, I wanted to explain this real quick because it is a bit confusing. As it says here, it appears the application requirements under Article 5 are satisfied. And here is Article 5 of the Constitution, saying that the Congress, on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments in the plural. It's important that I say that is amendments. But you'll see here the map, and only for 2/3 of the legislatures, that's only 34 states. So here we are, while in progress, here's where we stand today. 34 states are required to force Congress to call the convention. The call by Congress is peremptory and requires immediate obedience. Because you see up here it says, on the application of the legislatures of 2/3 of the several states, Congress shall call. There's no debate about that. They have to do it. So where are we today? We are at 38. 38 states. Here in blue, you'll see the states that have applied, and the red are the ones that applied and then rescinded those applications. The white states over here, we've got 3 of them, Washington, Maine, and Connecticut. You folks out there from those states, you are not yet counted. We know that you have applied, but you are not yet counted. And where is this being counted? You can click on this map and you'll see it'll jump out to the clerk of the House of Representatives.gov selected memorials website. And here you can see a list of what they've begun to put up. There's 182 of these applications and rescissions. And these really are only purporting. Each memorial purports to be an application of the legislature of a state calling for a convention pursuant to Article 5 of the Constitution. That's actually important because these are all asking for a convention pursuant to Article 5 of the Constitution. What is that again? This is a convention for proposing amendments in the plural. There's no other requirement other than 2/3 of the legislatures. It's a simple numeric threshold. And again, on their website, they're showing 182 results. And if you bothered to go through them as we have, you would see these 38 states still have standing legal application as by their own records. So we wanted to include this information from the clerk of the House of Representatives, but all of a sudden they stopped allowing us to embed the web page. So you can see here the clerk of house.gov refused to connect on this, allow people to embed this information. We used to have it there. They don't let us do that anymore. So that's a shame because that is public information at the clerk of the U.S. House of Representatives. So we wrote them in 2019 once again to get them to try to move on this. We included the information. You can read the letter here. We're really supporting the Transparency Act because there are 2 things that need to be accomplished for Congress to call the Article 5 convention. We need to create a bicameral collection of Article 5 records, and the Transparency Act, the Article 5 Records Transparency Act, would accomplish this by assigning that duty to the National Archives. The second thing we need to do is get Congress to create a rule that allows both houses to respond to the applications for a convention in a joint session of Congress. Apparently, one house or one member of Congress or a committee, or that's not enough. A whole house of Congress is not enough. Apparently, it must be the entire Congress in a joint session. That rule is not created. There is no process for that, so they cannot respond to the applications. They don't know what the tally of the applications is. They're just putting them up on that website. So we don't have a number, and the number must match what is in the Senate too. So that's why we need to create a bicameral collection. And having the National Archives responsible for this doesn't allow Congress any discretion over those applications. The National Archives would simply report that threshold has been met to Congress, and they would respond. So the Article 5 Records Transparency Act is awesome and is exactly what needs to happen, but it died. And so Congress is not responding. We reminded them again, you need to do this. You need to pass this so that you can obey. And we reminded them, and we showed them that the number of these petitions, the backlog of these petitions from states is simply staggering. And it is. There's records in the congressional record that are over 700 entries in there for these for the convention, and they have yet to count these even once after 200 odd years. You would think that they would finally get on the ball, but still they are not. And so far they haven't acknowledged anything that was even submitted before 1960. So here is the history of the letters that we sent them starting back in 2013. And we requested an official count because there wasn't one, and we were tired of guessing which states had applied and which had not. And they responded here. You'll see the legal counsel of the Office of the Clerk of the House of Representatives wrote back to me, and you'll see here that they're unable to fulfill our request. You can read it right there. They scanned a copy of the letter. Kind of incriminating that they would do that. The Constitution, I reminded the House, I sent them the map saying, you can look at the website yourself. Here's how it works out, 38. It hasn't changed in the last year. They haven't added anything else. They're not bothering to even obey their rules to put these things up. Again, we've got Congressman Polis had helped us in 2017. We've got another letter here. Basically, he was helping us identify what the problem was in Congress. What rules do we need that are preventing us from moving forward with this? And he's where we came up with those two items right there, and that was from Congress themselves. We know exactly what needs to be done. Parliamentarian here wrote back to Representative Polis, confirming what was in the rules that are there, and here it's like a page and a half. There's only a page and a half that directs Congress on any of the rules pertaining to Article 5. So not too much. Not too much at all. So they're really just going by what's in the Constitution, because Congress has failed to create rules for itself so that they can obey Article 5 of the Constitution. Furthermore, you'll see down here subject matter. Some people may tell you that subject matter has to match up on the application, or Congress can't add them together. Well, on their list over here, you're not going to see a pile of applications for one subject convention and another pile of applications for another. These are simply the year of receipt, the state, and whether it's an application or a rescission. So we this was part of a some disagreement among different Article 5 advocacy groups that are out there. So we asked Jared Polis's office and Assistant Eve Lieberman to contact the Congressional Research Service to clarify the question. Is there a subject requirement when you tabulate these applications? And here is the scanned copy of the printed out email. Or is a screen grab, or whatever it is. But here it is from Eve Lieberman at the House Government .gov email address. You can see that writing back to us. Please see the CRS Congressional Research Service response regarding the Article 5 question below. Specifically, you asked for confirmation that there is no law, court ruling, rule, or constitutional clause, etc., in existence that would instruct Congress to aggregate applications from state legislatures by subject matter to calculate the number of applied states. And he said the answer to this at the Congressional Research Service, so this is the information that they go by. They responded by saying, although various organizations advocating an Article 5 convention assert that Congress is required to record and aggregate the applications of state legislatures for such a convention to consider proposal of constitutional amendments, there is no specific language in the Constitution or U.S. Code that requires this, or that specifically any particular procedures by which these applications should be retained, organized, or made available for public inspection. So, we got them to create this list back in 2015 in response to the letter that we sent in 2013. It took quite a long time before they even started making these transparent. But it's not for both houses. This is just for the House of Representatives. So they have yet to actually make these organized or made available for public inspection as a whole. He's correct about that. They've just begun to do that. So it's missing applications and doesn't go back nearly far enough. It's missing a lot of applications, actually. So let's see here. But, I mean, you basically got the requirements right there. We've got enough states. We've got actual copies of the applications. When we sent them the original letter, if you go back in the About Us section here, you'll see from the original letter back in 2013, if you hit download, you can actually see the scanned copy of the original letter, which included the scanned copies of those congressional record entries. And I'll just give you a peek at it real quick here, just so you know I'm not pulling your leg. It's loading slowly because it's actually a pretty hefty document. There's 50 pages to this. So here's the original letter. Looks all crispy and new there. And again, these are scanned copies directly from the congressional record. And we sent them 42 states with what we believed was standing applications. A lot of these are old, and they have yet to even address any of them that we sent. We didn't necessarily go by, what was the newest by any means. We looked for what was in the record that was clear and undisputable as far as whether it was an Article 5 application or not. And we wanted to ask them to verify these, whether it's correct, and if they're going to be accepted as, we wanted to see how they would handle that. So how they handled it is not very good. We have to give failing marks on that one. So again, they're still in progress. Put very little up in the last couple of years. I'm not very hopeful that they're going to do a whole lot more in this regard. So that's what it's talking about here. When the requirements under Article 5 are satisfied, it's right there. You can see that they are satisfied, and that Congress just doesn't have the ability to respond to these things. They never created that process to respond to these things conveniently. So we're not waiting anymore. We're going to go ahead and on July 4th, visit us again, and you're going to see we're going to start an online convention. We're going to assemble in a citizens convention to propose amendments. We have a right to alter or to abolish our Constitution as stated in the Declaration of Independence. We have the requirements met to do this, and we have the right to assemble and petition for a redress of our grievances. And what better way to do that than in an assembly? So look forward to debating with y'all in July of 2021.